Good morning, everyone. You are all welcome to today's webinar on the data protection regime in Ghana. Thank you all so much for joining us here today. My name is Sherilyn Aholu, a senior consultant with the tax and regulatory team here in Deloitte. Kindly note that this session is being recorded and will be posted on Deloitte's YouTube page. Also note that all participants are currently muted, and towards the end of the webinar, you'd have the opportunity to unmute to ask all your questions. In the meantime, you can drop in your questions or comments in the chat box and would attend to it during the Q&A session. A feedback link will also be provided towards the end where you'd give us feedback on the webinar. Now, this webinar is in two parts. Our very first part will have the Data Protection Commission. We'll have a speaker from the Data Protection Commission take us through the key compliance requirements and insights for all entities in Ghana. Our second segment, we're going to have a panelist discussion where the Data Protection Commission and Deloitte are subject matter experts, take us through the challenges and the common pitfalls that entities face in trying to meet their compliance requirements. At this stage, I would like to invite Mr. Wisdom Pano, our tax and regulatory partner here in Deloitte, to give us the welcome address. Thank you all. Wisdom.
All right. Thank you very much, Sherilyn. And good morning once again to everyone. And thank you for joining our webinar on the data protection regime in Ghana, focusing specifically on compliance and requirements for entities. It's a joy to have you join us this morning. We are delighted to have you join. And this morning, we are going to explore provisions of the Data Protection Acts 2012 Act 843 and its significance for organizations operating in Ghana. The Data Protection Act was established to help establish the Data Protection Commission, whose mission is to protect the privacy of individuals and their personal data by regulating the processing of personal information. The Act also outlines the processes for obtaining, holding, using, or disclosing personal information. And this ensures every entity understands its responsibilities in safeguarding the privacy of individuals or the rights of individuals. And as organizations, it is crucial to embed data protection practices within our operations. And this not only helps us comply with legal requirements, but also builds trust with our clients and stakeholders. So today's session will provide valuable insights into the compliance framework and practical steps to implement data protection effectively. I look forward to having an engaging discussion this morning. And it's my joy to also mention that we are doing this in collaboration with the Data Protection Commission. So this webinar is rich with perspectives from a business consulting side and also from the regulator. And at this time, it's a pleasure to introduce none other than the Director of Regulatory and Compliance at the Data Protection Commission, Mr. Quentin Akrobeto, who we have the pleasure of hosting this morning to be our guest speaker to share some insights on this very topic and also give us an official address for this all-important gathering. So, Mr. Akrobeto, it's a pleasure to have you and to specifically have the Data Protection Commission join us this morning. Thank you, and your audience are eager to hear you.
All right. Thank you very much, Wisdom. I must say it's a pleasure to join you this morning to discuss this very important topic. It's a topic that has become very central in modern governance, business operations, consumer trust, and digital transformation within the country and globally. So thank you very much. Let me use the opportunity to actually thank your audience, our distinguished participants, representatives from Deloitte and Touch, colleagues and all who have made it a point to join this webinar this morning. I thank you all for the opportunity. So let me start by bringing our attention to the fact that globally today, organizations increasingly rely on digital systems and cloud technologies, artificial intelligence, mobile applications, digital financial service. Almost every organization or institution rely heavily on personal data as a valuable asset in order to improve upon their game, in order to improve on their services to their customers. It is within this context that Ghana established a formal legal and regulatory framework for data protection through the enactment of the Data Protection Act, Act 843, and the establishment of the Data Protection Commission. What the Act seeks to do actually is to protect the privacy of individuals by regulating how organizations or institutions process personal information and ensure that organizations actually handle personal data in a manner that is responsible, lawful, and secure. The Ghanaian data protection regime is built around a number of foundational principles. This include accountability, lawful and fair processing, purpose specification, data minimization, security safeguards, openness, and protection of data subject rights. In practical terms, this means that organizations must not only collect personal data lawfully, but must also be able to demonstrate that they have appropriate governance controls and safeguards in place throughout the data lifecycle within the organizations. One of the most important aspects of the regime is accountability, data protection or data governance accountability within organizations. The Commission increasingly expects organizations to move beyond paper compliance and demonstrate operational compliance. As I've mentioned, in today's environment, compliance is no longer simply about having a privacy policy on a website. It requires organizations to embed data protection into governance structures, business processes, procurement arrangements, technology deployment, employee awareness, and risk management frameworks. Under Ghana's legal framework, entities that process personal data are generally required to register with the Commission as data controllers. However, registration alone does not amount to compliance. Registration is intended to serve at the beginning of an organization's accountability journey and not the end of it. Organizations are expected to implement appropriate technical and organizational measures to protect personal data against unauthorized access, disclosure, alteration, or misuse. This includes measures such as access controls, encryption, employee confidentiality obligations, incident response procedures, and oversight of third-party processes that we engage within organizations. Increasingly, we are also seeing growing regulatory attention around areas such as cross-border data transfers or processing, cloud computing, cybersecurity governance, artificial intelligence, biometric processing, and digital financial ecosystems. Organizations must therefore understand that data protection compliance is not isolated from broader digital governance obligations. It intersects with cybersecurity, operational resilience, consumer protection, and enterprise risk management. Another important feature of the Ghanaian regime is the protection of data subject rights. Individuals have rights relating to access, correction, objection to processing, and protection from unlawful disclosure of their personal information. Organizations, therefore, must establish internal procedures to receive, access, and respond to such requests appropriately and within reasonable timelines. From a compliance perspective, there are several key expectations that organizations should prioritize. First, organizations should establish a clear internal governance structure for privacy and data protection. Responsibility for data protection should not rest solely with the IT department. It requires management oversight and institutional accountability. Secondly, organizations should understand the personal data they process. Many institutions struggle with compliance because they do not have visibility over the data they collect, where it resides, who has access to it, how long it is retained, or whether it is shared with third parties or not. Thirdly, organizations should implement policies and procedures governing data handling, retention, access management, breach response, employee conduct, and third-party processing arrangements, as I've mentioned earlier. Staff awareness and training remain critical. Many data breaches arise not necessarily from sophisticated cyber attacks, but from human error, weak internal controls, and poor handling practices. Let me finally say, organizations should adopt proactive compliance culture. Regulators globally, including the Data Protection Commission of Ghana, are increasingly moving toward evidence-based accountability models. The question is no longer simply whether an organization claims to comply, but whether it can demonstrate compliance when required by the regulator. As Ghana's digital economy continues to evolve, strong data governance will increasingly become a competitive advantage. Consumers, investors, and international partners are placing greater emphasis on privacy, trust, and responsible data use. Organizations that invest in robust data protection frameworks position themselves not only for regulatory compliance, but also for improved consumer confidence, operational resilience, and long-term sustainability. In closing, let me emphasize that data protection should not be viewed merely as a legal obligation or regulatory burden. It is an essential component of responsible digital transformation and sustainable business practice. Thank you very much. All that I have mentioned to you, we will get the opportunity of doing a presentation on by my colleague who is also on this call. And in the interaction during the panel discussion, we'll get to touch on some of these things that I have mentioned. Thank you very much for your audience.
Thank you very much, Mr. Quentin Akrobetu. It's been a very nice introduction to this very all-important session. To continue, we need to gauge the expectations of our audience. We'll bring up a short poll for our audience to engage. Let's know their expectations. What are the key reasons why they are here, and are they even aware? What is the level of understanding they have when it comes to the data protection, and what do they expect at the end of the session? So the post will come up. When they come up, please let's engage. Let's everybody respond so that it will guide, especially the moderation session, the panel discussion. So the posts are up. The first question, which best describes your organization's data protection approach today? So you choose one. If you think that it's fully risk-based and embedded, if you think it's basic compliance currently, you think you're currently at the level of minimal compliance, or you think there's no structure at all in your organization. Okay. Responses are coming. Yes. Okay. So the basic compliance is quite leading at this stage. So we'll give some few seconds again for us to run up on the first question. Then we'll move to the second. Okay, some are already at the second. That's good. So once you finish the first, you can move to the second. Once you are done with the second, you can move to the third. So basically, in the first question, we notice that basic compliance is what a lot of people are currently engaged with, and that is good. At the end of this section, we expect that there'll be more understanding, and we'll move from basic to full compliance. And then the second question, when it comes to what is the main challenge your organization faces in complying with data protection, um, your major one is the leading one is regulatory clarity. So we have the regulator here, who believe at the end of this session is going to provide enough clarity, and that would lead to compliance. And we also have lack of internal expertise. So of course that will also come up. The experts are going to be on this call to help. This very important webinar to help guide you on what to do next. And then, of course, the last one, what is your primary expectation from this webinar? I think a number of us just agree that it is understand data compliance obligations. So on this note, we would bring the poll to an end. We can end the poll now, and then we'll move to the next session. I think we've gotten a fair idea what compliance status our audience currently are obliged with, and then we also know what they expect at the end of the session. Okay, so having done the poll, we'll move to the next session. As Mr. Quinton Akrobeto rightly said, we are going to have Mr. Felix Otabel, the lead compliance officer with the Data Protection Commission, come and give us a 50-minute presentation on what we expect to know, what is data protection in the first place, and what expectations should we have, what do we need to know, what compliance obligation exists. I'll hand over on this note to Felix. Felix, if you are ready, you can take over and then proceed.
Thank you, Augustine. It's a pleasure joining Deloitte to have this session. Without wasting my time, my name is Felix Edufulo Tabo, Lead Compliance Officer with the Data Protection Commission. Today, we are going to discuss or talk about the compliance requirement for entities. And before I start, there was an enactment of a data protection law that established the Data Protection Commission. And this enactment has given key responsibility to some of us to work at the commission to help propagate the mandate of the Data Protection Commission. So the question is, what is the mandate of the Data Protection Commission? The mandate of the Data Protection Commission is to regulate the processing of personal information and also regulate the processing of obtaining, use, and disclose of personal information. So what does the commission do? The commission have a lot of things in place that we perform as some of our activities. So we protect individuals' privacy by regulating the processing of personal information and putting in place the relevant measures in place for organization to respect individuals' privacy rights. There are
Felix,
trainings that we also.
sorry, allow me to interrupt a bit. Can you put your slide in presentation mode so that it comes up clearly? Okay, that's fine. Thank you. You can proceed. Felix, you are muted
Mr.
if you are
Felix,
speaking.
it's fine now. You can
Yes,
proceed.
it's fine, so you can proceed. Hello, Felix. Okay, so we'll give Felix some few seconds to adjust and then resume his presentation. In the meantime, Ben, if you're able to unmute him, in case he's having challenges, unmute him.
My phone muted, but it looks like
Hello.
yes, we can hear you now.
Okay, we can hear you now.
Yes, am I audible now?
Yes. Please
Okay,
proceed.
thank you. Thank you for the opportunity. Today's we have a brief section on data protection regime in Ghana, and the main key focus area is on compliance requirements. So there is a law by name Data Protection Act, which established the Data Protection Commission, and this act has given mandate to the commission to fulfill. And the mandate of the Data Protection Commission is to protect the privacy of the individual and personal data by regulating the processing of personal information and provide the process to obtain, hold, use, or disclose personal information. It's a fundamental human right that is even enshrined in the Constitution, Article 18.2, which suggests that your privacy must be respected as an individual within our jurisdiction. So the question is, what does the Data Protection Commission perform? What are some of the duties, or what do we do? So basically, what we do is to protect the privacy of the individual and personal data by regulating the processing of personal information. We have training programs in place that will help equip individuals to monitor compliance with the provisions of the law. We examine and conduct investigation into complaints. We keep and maintain an up-to-date data register of data controllers. We support data controllers to comply with the with the data protection legislation. We raise data protection awareness, and we also protect the privacy. We protect personal data by regulating the processing of personal information and provide the process to obtain, hold, use, or disclose personal information. So the question is, what is data protection? Data protection, we've been hearing the name. What does it mean? So I have a very simple statement here, which reads, data protection is the fair and proper use of information about people. Practically, data protection is about building trust between the people and the organization. So the law has described the people as data subjects. You, the participant on this forum, the law describes you as a data subject. Me, the speaker speaking on this forum, the law describes me as a data subject. And the data controllers, then every entity that collects personal information for a specific purpose, the law describes you as a data controller. So the law has given the data subjects legal right for them to exercise. We have about 10 legal rights that we are enjoying under the Data Protection Act. One is right to be informed. Right to be informed has led to organization defining their legal basis for processing personal data. And you know, some organization, one of the key things they have considered in processing personal information is to seek your consent. There are other lawful bases under the law which also help organization to use their lawful basis to collect personal information. Contract is another one, and among others. So the law is saying that if you are an entity or you are a data controller, you must follow the data protection principles. The first principle is the principle of accountability. We have lawfulness of processing personal information. We have compatibility of further processing with purpose of we have compatibility of further processing with purpose of collection. We also have openness, data subject participation, and among others. So in this space, once you are an entity and the law has described you as a data controller and you have the intention to process personal information, you must register with the Data Protection Commission. It is just like you have purchased a car and you want to drive on the road. The law is saying that before you drive on the road, you should acquire a driver's license. Simply put, the data protection regulation is also saying that if you are an entity and you have the intention to process personal information, the law is saying that acquire certification from the Data Protection Commission before you process. The law is saying if you do not acquire the certification and you process personal information, it is an offense. And you can make reference to that in Section 56 of the Data Protection Law. It reads that a person who fails to register as a data controller but processes personal data commits an offense and is liable on summary conviction to a fine of not more than 250 penalty units or a term of imprisonment of not more than 2 years or to both. So there is a significant reason why as an entity, you must demonstrate data protection compliance under the law. The same law is saying that if you are an entity and you are processing personal data within the space and you have not registered, it is an offense. Section 53, a data controller who has not been registered under this act shall not process personal data. So the question is, how many organizations are processing individuals' personal information that have not registered under the Data Protection Commission's requirements? So with the purpose of this engagement, stakeholders that are on this forum at the moment, if your organization have not demonstrated data protection compliance, advise them to do so. So what are the importance of data protection? The importance of Data Protection Commission build trust with stakeholders. People will trust your brand. People will trust the process you collect personal information because the law is saying in Section 18 that before you collect personal information, it must be lawful. So are you collecting personal data lawfully without infringing the privacy rights of the data subject, which I've defined in my earlier presentation that you, the individual on this forum, the law describe you as a data subject. So the law is saying that if an organization is processing your personal information and it is not in accordance of the data protection law and it is infringing on your privacy rights, then the processing is not lawful, it's unlawful. The next significant is prevent data breaches and cyber attacks. Once you put in place the relevant measures in place and you are in full compliance with the data protection regulation or the law, it gives you an avenue to put in place the relevant measures to prevent data breaches and data attacks. Even though you cannot, even though breaches are bound to happen, you cannot completely say that you put in place the measures and there will not be any breach. But it gives you all the relevant measures to put in place, all the mechanism in place. Have your breach register, have your incident and breach management procedures in place. Once there is a data breach, you know how to address some of these things. And it helps to avoid fines. Just like I said, 53 and 56, that is saying that if you process personal data and you have not registered with the Data Protection Commission, it is an offense. There are general penalties in place that if you fault against the data protection law, these sanctions are applied. And it helps you to protect the privacy of the individual. So the main thing as an organization, once you put in place the relevant measures to demonstrate data protection accountability, one of the significant is to protect the privacy of the individual because the individual have legal rights that he can exercise. And one of the legal rights the data subject can exercise is right to complain. you have the right to complain when you find out that your personal data is not being processed in accordance to the data protection law. You have the right to object processing. You have the right to withdraw consent once you consent to processing of personal information and you find out that the processing is unlawful. The next section is for us to talk about the legal obligations. Simply put, legal responsibilities. So these are the responsibilities as an entity that has been defined under the data protection law you are mandated to fulfill. One is to register as a data controller. This is in reference to section 2746. There are other sections that requires that you must register under the law. Even government departments are not exempted from this registration once you process personal information. Because if you read section 91 of the data protection law, it reads that this act binds the republic. Subsection 2, for the purpose of this act, each government department shall be treated as a data controller, and each department shall designate an officer to act as a data protection supervisor. So data protection is premised on processing of personal information. So either being a government department or government agency, or you are an entity that collects personal information for a specific purpose, the law is saying you must register. Same law is saying that you are required to renew Section 50 of the Data Protection Act. So every 2 years, you are mandated by law to renew your certification. Section 50. It reads that a registration shall be renewed every 2 years. Point 3, appointment of a data protection supervisor. The law requires that once you are a data controller, you must have a designated data protection supervisor to monitor compliance with the provisions of the law. There is a regulation around this section. The letter of the law uses may. If you read section 1, it reads that a data controller may appoint a certified and a qualified data supervisor to act as a data protection supervisor. But the Data Protection Commission, in their administrative arrangement in section 5, section 3 of the Data Protection Act, mandates that the commission makes an administrative arrangement it considers appropriate for the discharge of its duties. So with this section, the Data Protection Commission have come up with administrative arrangement which simply says that if you are a small data controller, you are not mandated to appoint and train a data protection supervisor. So these guidelines that I'm about to speak on, point 3, has been published on the data protection website. And the caption is guidelines to demonstrate data protection accountability. When you click on for organization, the Data Protection Commission's website is very, very user interactive. So there are sections for organizations and there are sections for data subjects. And these sections that talks about the data controllers, your legal responsibilities, has been published on the Data Protection website. And so medium and large data controller, the administrative arrangement in places, you should have a designated data protection supervisor. For small, you should seek help from data protection practitioners who are experts in the industry to help you demonstrate data protection and accountability. The Data Protection Commission is saying that you cannot contract other experts for them to help you comply or monitor compliance with the provisions of the law. the guidelines is saying that even though you contract someone by contract to help you do this, one of the key things the person must advise you is to have your in-house designated data protection supervisor to help you monitor compliance with the provisions of the law. So all these measures has been well defined in the published document on the website. And as a data controller, you are also required by law to implement technical and organizational measures to demonstrate data protection accountability. So the likes of encryption, password protected, lock with key, and among others. You must put in place the relevant measures. The Data Protection Commission cannot recommend to you the kind of security measures that you have to adopt because you know how the Data Protection Commission cannot recommend the kind of security architecture you must adopt because the law set forth that a data controller shall take the necessary steps to secure integrity of personal data in the possession or control of a person through the adoption of appropriate, reasonable, technical and organizational measures to prevent loss of damage to or unauthorized distraction and unlawful access to or unauthorized processing of personal information and among others. There are a lot of these things that has been defined very well what the data controller must do. The Data Protection Commission cannot say that use XYZ security measures because the law is saying that use security measures that are appropriate, reasonable, technical, and organizational measures. What the Data Protection Commission is interested in when we come to inspect you, we must see some of we must see these controls that has been implemented and it is effective. The next one is design solution following data protection principles. There are key principles that organization must follow. Just like I said in my earlier submissions. Practically, data protection is about building trust. The data controllers are required by law to follow the data protection principles. So if you read section 17, it talks about the key principles that organizations must follow. Just to mention a few, we have accountability, lawfulness of processing, specification of purpose, compatibility of further processing with purpose of collection. I am very interested in this one, compatibility of further processing with purpose of collection. People collect personal information for, let's say, let me put it in practical terms with no the same. People will collect personal information to sell clothes to you or maybe give you a medication. The next minute, they are selling you, they are sharing with you an advertisement to come and buy clothes. This is unlawful. When you collect personal information for a specific purpose and you have other agenda to use that personal information for another specific duty, you are mandated by law to seek the consent of the individual. The moment you collect the data for XYZ purpose and the next minute the person have no consent, or let me use this word, the person has not agreed for further processing for you to use their information for advertisement to sell shoes, bags, and other things to them, it is an unlawful. It is a breach. It's a compliance breach in accordance to the data protection regulation, and establish a privacy program. So you must have continuous training in your organization to give a general awareness to management, board, staff, even to the security man. The security man must appreciate the significance of data protection. It is your core responsibility for you to educate any person within your jurisdiction to be data protection conscious or privacy conscious. So these are the key things as data controller you are mandated by law to fulfill. There are more to that when you start practicing this. So the next one is, what is the role of a data controller and a data processor? But before I start this discussion or this explanation, the question is, who is a data controller and who is a data processor? If you read the interpretation of the data protection law in section 19 of the Data Protection Act, it reads that data controller means a person who either alone, jointly with other persons, or in common with other persons, or as a statutory duty, determines the purpose for and the manner in which personal data is processed or is to be processed. And let's look at the interpretation of who a data processor is. Data processor in relation to personal data means any person other than an employee of the data controller who processes the data on behalf of the data controller. So let's look at the relationship now. By default, every organization is a data controller. By default, once you have the intention to collect personal information for a specific purpose and you register under the Data Protection Act, you are a data controller. Your nature of processing changes. Let me repeat that. Your nature of processing changes to become a data processor when when there's an agreement between company A and B. So company A and B, you are all data controller. The moment there is a contract between company A and B with an instructions on how to process personal information, then your nature of processing changes from a data controller to a data processor. So Data Protection Commission is a data controller. The moment the Data Protection Commission comes in with an agreement with a third party, let's say a payroll management company, to process payroll for staff, that organization becomes a data processor. And how does this happen? So there will be a written contract agreement for this to happen. So there should be a documentary evidence to evidence that there is an agreement between two parties and it covers the scope and purpose of processing, instructions from the controller how to use XYZ personal information for a specific purpose, confidentiality obligations, security measures, breach management procedures, and after the process, the data controller will inform the company A, will inform company B to delete or return all information that has been given. So simply put, this is the clear relationship governed the role of a data controller and a data processor. So in simple practice, there should be a relationship governed by a written agreement. Once that is established, your nature of processing now becomes data processor. Once this agreement is not established, you are a data controller. So how can an organization that has been described or defined as a data controller register with the Data Protection Commission. So these are the key steps as an organization or an entity. Once you have the intention to process personal information, these are the key processes you must follow to register to acquire certification. And once we go through these processes, I will talk about after registration whatness, beyond registration whatness, the key things that you must do before you renew. This is one of the most challenging issues within our space after registration whatness. So let's look at how a data controller can register and acquire certification with the Data Protection Commission. It is very seamless. Once you visit the Data Protection Commission's website, once you type dataprotection.org.gh in your URL or your search engine, you have access to all the information. You click on register to create an account. You activate your account. Then there are details that are required for you to complete the registration process. And these are the major requirements that we need from the data controller to register with the Data Protection Commission for them to acquire a certification. The first one is your business certificate of incorporation. That comes with your business TIN and registration number, your entity category. We want to find whether you're a sole proprietor or limited liability or limited by guarantee, your address, your sector, description of services provided, your annual turnover, your average number of data subjects whose personal data you process. So number 7 is talking about the average number of individuals, your clients, your third party, your employees, and among others. Once you have certain information in your custody, the commission would like to know the number of data subjects whose personal data you process, your average annual number of records of personal data that you process. Then we would also like to find out from you whether it's a part of group of companies with at least one entity as a live data controller or a processor, and your reason for processing personal data. What
Hi,
are your
Felix.
reasons? Hi.
Yes, because we'll be going into the details in the panel session, the moderation session. If you wrap through those ones, and then we'll have time to delve into them deeper when we get to the panelist discussion.
Thank you. I'm almost done. So what I was saying, beyond registration whatness, these are some of the key things that you are required to put in place before you renew. All these things, the Data Protection Commission gives you this information ahead of time. So once you register, you acquire your certificate, this information is being shared with you via email, and it is even in your data protection account. So there is no way you will say you are not aware. We have published this on the website. In your data protection account, it is in there. When the certificate is ready, we email this to you that put these measures in place before you renew. 1, appoint and train a data protection supervisor. If you appoint, the next line of action is to book a certified data protection supervisor training. When you are done, you perform compliance assessment or an audit. You draft your compliance assessment report and submit it to Data Protection Commission for review, approval, and an inspection. So the next one, document and implement technical and organizational measures. Establish your privacy program, that is the awareness training. And the next one, you prepare for renewal. So how do you prepare for renewal? You go through the process, you go through the same process again, you log into your account, you click on renew license, you update your applications. So how that you update your application on your dashboard, you click renew and update details, just like I was saying. When you are done, the portal will generate an invoice for you for payment. The portal is very seamless in a way that once you generate and make payments, it gives you an access to upload evidence of payment. So we have direct payments. You can pay either using Momo or your card. Once you get to that section, you select your preference. It's either you go to the bank, you pay with Momo, or you pay with a bank card. Then once you are done, if you go to the bank, once you make payment and you are through with the payment, you come back to your account, you log in and upload evidence of payment. Within 24 hours, you receive the compliance assessment template for you to report the assessment that you have performed. And you submit your gap analysis. It's the same as the compliance assessment for review and approval. Then within 21 working days, after all these processes, once you satisfied all the Data Protection Commission, their requirements within 21 working days, your certificate is ready. If you fulfill these processes chronologically, you realize that it will not take even 21 working days for you to get the certificate. Then you get prepared to be audited or inspected. Thank you for giving me the opportunity to present to you the requirements for data controllers to demonstrate data protection compliance under the data protection law. Thank you very much.
Thank you very much, Felix. This has been very detailed, and I believe our panelists will agree with me that this has been a very insightful session already. It's already beginning to be very engaging. Now, we did a poll briefly earlier. I would like us to take a look at the results and see where our interest lies and the status of compliance. So we have it on our screen. For the first question, which best describe your organizational data protection approach today? We have 68% saying basic compliance, which means it is minimal. Not much, but it is still not up to the expectation. Then we have full risk-based and embedded, which is the second. So that's good to know that we have some that are full risk-based. And then the third, we have 15% saying that minimal compliance, and then 6% no structure at all. Then the second question, we have which is the main challenge your organization faces in complying with Ghana Data Protection Act. We have the highest being 41% saying regulatory clarity. So Felix, that is where you come. You've done a good job already, providing some clarity. The next session is going to provide further clarity. Then we have lack of internal expertise. So 30% say they lack internal expertise. We'll see how our panelists help us to address this concern and guide you. Then we have 19% saying data security implementation. That will also be addressed, and then cost of compliance. We'll see how that one also goes, whether the cost is that huge and what data protection can actually do in that regard. Then the next one, we have what is your primary expectation from this webinar with regards to data protection? We have 61%, that's good, saying they want to understand data compliance obligations, which is exactly why we are here. And we have 18% saying gain regulatory clarity. And then we have 12%. So just a minute. We have the last one. Okay, so we have what is your primary expectation? We have 10% who say build internal capacity. So these are our feedback and what we expect of this training. We'll proceed to the very next session. Augustine Donko, your moderator for today's session, and with me will be Felix Otaba, who has already taken you through the some compliance obligation. He's the lead compliance officer with the Data Protection Commission. Felix, nice to have you.
It's a pleasure to have you, Augustine.
Thank you. And then next is our own partner from Deloitte, in the person of Wisdom Pano, the partner for tax and regulatory, leading the regulatory and international tax business in Deloitte. Welcome, Wisdom.
Thank you. Thank you again.
Okay, then now we have Nina, an associate director with the technology and transformation team also helping with cybersecurity issues. Nina, welcome and nice to have you.
Thank you, Augustine.
Okay, so we'll start. That's the first bite. Let me start with Felix. You've taken us through a whole lot already. Now, in your work, Felix, what will you say are the common pitfalls and compliance issues that you observe? Let's say the non-compliance failures that you observe as a regulator. And before you even go into that, first tell us, we know in recent time you'll be engaging, we'll be seeing you in the public, having some discussions around trying to educate the public on the need for data compliance. How's that been?
Oh, it has been very interesting one. Data protection is like I eat and drink data protection every day. So anytime I engage people, I try my possible best to explain data protection compliance to like I am explaining it to a primary 5-year student so that the person can appreciate that I have a legal responsibility under the law. And even if the person is an organization, I try my possible best to explain it to them that, hey, these are the key things, like what I did, 6 major bulletin that you must fulfill. The moment you start fulfilling them, then you are good to go. But it has not been an easy one. It has not been easy at all. But for the love of the country and other things, we are trying our possible best for people to appreciate data protection compliance and also do the needful as required by law. It has been a very challenging one, but we are trying our possible best. And one of the most important thing, or what interests me the most, is stakeholders also advocating for this, and like your organization, reputable organization like yours, also coming to the commission that, hey, we want to join this movement. Data protection now is a movement, and we entreat every organization or stakeholders. The government cannot do it alone. They should also support the Data Protection Commission for us to propagate the message for people to comply. It has not been an easy road, but I think Jimmy Clef said we have so many rivers to cross, and we are on the journey. As I'm speaking to you now, I am in Tamale to also preach this same gospel to people, and also impact people to become data protection supervisors, for them to also help organizations
Definitely.
demonstrate data protection accountability. It has not been easy, but it is a good journey.
Definitely, definitely. So from our poll, Felix, you tell there are a number of people primary objective, they want regulatory clarity, and that comes with the question: what do you notice from where you sit as the lead compliance officer at Data Protection Commission? What are the common pitfalls, the non-compliance areas you identify, the failures that organizations usually come? When they come, what are the issues you usually identify?
The issues that we identify is the clarity, but this clarity has been published on our website. We have done all the necessary things for people to appreciate this regulation. But sometimes I ask myself, uh, are these people reading or not reading? Or is it that we are not explaining things in a plain language for them to understand, to appreciate their legal responsibilities under the law? But I think for, let's say, some years ago, it was very bad. But I think now the education is the education is more, and people are trying to pay much attention to it. Even though they keep asking the same question, but I think for now, I can say we've moved from 30% to 50. So old questions like, I am not aware that we should appoint a data protection supervisor. Oh, I am not aware that I have these legal responsibilities, that anytime an organization is willing to collect my personal information, I have the legal right to ask questions. I have the legal right to ask them questions. Are you registered with the Data Protection Commission? Even the commission have published the register on the portal. So any organization wanting to collect your personal information, you, the data subject, you have the legal right to check them whether they are compliant to the Data Protection Act or not. But I think this has been the major issues,
The major
and I think,
issues first.
yeah.
Yeah, so from your end, you think you've done all, and you still do not know if you are not doing it right. And that's why I bring in Wisdom panel. Wisdom, you have been engaging client organizations, companies, and trying to assist them with the compliance. Beyond the box ticking exercise that some may want to do, what really do you think are the issues now that organizations face from your perspective as a consultant?
Yeah, right. Thank you very much. And maybe before I go on to my question, just to congratulate Felix again. That was a very good presentation, very apt, giving the key provisions in the Data Protection Act, and also I like the practical aspects, what to do, and the step way to do it. And I'm happy we are even having this deeper conversation, especially around the practical ways to protect your data. And I believe that's where Nina Colley will come in from a cybersecurity point of view to give some practical guidance around the tools to put in place to safeguard personal data so that we will be in compliance with the Data Protection Act. But to your question, what we see in practice, basically, the preparedness is improving, and from what Felix mentioned, once organizations are becoming aware of these legal requirements, we see better preparation in practice. Most organizations are still engaged in the tick the box approach, focusing on registration, putting policies here and there. But then I think a central theme I'll pick from the discussions we've had so far, from the keynote address, from the director, compliance, regulatory and compliance, and also from the presentation from Felix, it's quite clear that beyond the registration, beyond putting one policy here and there, it's important that organizations really work this into the framework of what they do on a daily basis. One thing stood out for me. It's important that the employees of organizations are carried along what they should be doing around data on a daily basis, how data impacts their daily work, and how they protect that data. And we need to put in that hard work, going that extra mile to put that governance framework around it. So generally, organizations seem to be moderately prepared, and the poll also shows the awareness we are creating with this helps. But then if you look at data protection, not just as a legal requirement, but also from a risk lens, then you'll be able to put in stronger accountability structures, practically putting in the tools, and then having continuous training so that it's not just one-off documentation of what needs to be done today, but it's more built into the organization, and people actually walk the talk when it comes to protecting data, personal data in that manner.
Thank you, Wisdom. So, Nina, let me come to you now. From the previous speakers and the presentation by Felix, it comes up as if it's not just about registering, but also about protection of those personal data. And that comes with cybersecurity. Now, how do we align, or as we say, how do we align data protection and cybersecurity? And what should be the baseline for cybersecurity in this conversation, in this whole conversation? Is there a meeting point at all, or they are distinct?
Okay, thank you very much, Augustine. And let me thank Mr. Felix for the wonderful presentation. I think for organization to be aligning the data protection compliance efforts and cybersecurity, they first have to recognize that cybersecurity, if you are talking about cybersecurity and data protection, they are like intertwined. They are fundamentally intertwined. The reason why I'm saying that, if you look at cybersecurity, if I want to put it in very basic level, cybersecurity is about protecting critical data. which critical data also will touch the personal data, to make sure that you have control in place that will help you to protect that critical data. And also to ensure that it's a continuous process to understand and mitigate the risk of your critical data being compromised or being accessed by people who are not supposed to have access to that data. And let's even look at it from the Ghana Data Protection Act. What is the core mandate? The core mandate is to safeguard the privacy of organization, the individual. And you can never achieve this requirement without implementing cybersecurity control. It's cybersecurity control that to help you to meet all these obligations that Mr. Felix has let us know this morning. So you see that now data protection has to rely on cybersecurity to be able to protect the data privacy. And also that the cybersecurity has also to be informed by the data requirement, because we have seen in many organizations, when you see that we have systems that are processing this data. But if you look at this system, they were not really built taking into consideration of the privacy. So the privacy was like afterthought. Meanwhile, they say that you have to make sure that the privacy, the data that you are collecting about the citizen, about individual, they are protected from the collection storing. But you see that these basic requirements, they were not taken into consideration. So I think that cybersecurity and data protection, they go together. And to be able even to achieve it, there are specific control, as Mr. Felix has mentioned. You need to have the right access control. Who access the data? And you need to make sure that your data is encrypted. We know that security will never be 100%. There may be instances that this data may be fall in the hand of the person that is not supposed to have that data. In such situation, can the person be able to identify that this data that I have pertain to Nina, or pertain to Wisdom, or pertain to Augustine? So you have to make sure that they are encrypted or they are protected. And also in case something happened, do you have incident response plan? That incident response plan should let you know what are the steps that you should take about, because cybersecurity can never be effective if the privacy program is not effective. But I have seen a lot of instances. You know, in Ghana, a lot of organizations has implemented the ISMS, the Information Security Management System.
Yes.
And also the Data Commission also requires that we have the privacy program. But when you go do assessment of the Information Security System Management, you see that there is a lot of gaps. And when you audit also the privacy program, there is a lot of gap. So you ask yourself, how come maybe the Information System Management program, if you want to measure the maturity, is at level 3 or 4, but the privacy program is at level 2? This raises some concern, because they are supposed to intertwine, but it's not. It's because that they haven't really embraced the culture to see that they go hand to hand. That's why we are seeing a lot of gaps. But I believe at the end of this webinar, which is also the purpose to let people know that there is no way you implement your privacy program without taking into consideration cybersecurity.
Cybersecurity.
If you do that, it's where you see that you are not compliant.
Yeah. Thank you so much, Nina. And that's a very good point you've just raised, especially about the compliance. And compliance begin obviously with registration. Felix has walked us through registration. To come back to Wisdom as a first point, you've helped clients and companies register with Data Protection Commission. Felix walked us through. Practically, what are the challenges you've encountered either from your side or even client themselves coming to you and complaining to you? What are the practical challenges that exist that you think probably are the reasons why some companies may still not be compliant, even though they want to?
Yes, thank you, Augustine. And I know Felix has mentioned the guidelines. What we've seen in practice, basically, I'll mention two. It's around companies registering, but then so incorporating in Ghana, but then do not go immediately into operations. That would mean that at that time they do not handle uh, personal data. The clarity around when to register, and if they only register after they actually or right before they actually start processing personal data. How will the commission take that? We've seen instances where such companies have been seen as non-compliant because the Section 27 of the Act says that a data controller who intends to process personal data shall register with the commission. For various reasons, companies do incorporate but remain unoperational until much later on. So to just get that clarity from data protection, how they view that and whether there's any system to monitor when you actually start operation and to trigger the registration requirement from that point. And then the second one, and more important in my view, is around the controller classification. So you talked about small controllers being exempted, but I see that this is linked to revenue. Again, we've seen a number of companies that are very lean in terms of personnel and the data that they handle, but then the 90,000 Ghana cedis threshold for small controller, they exceed that from a revenue point of view. So that's it creates a bit of disconnect in terms of they falling into medium or above medium data controller, but then running very lean, sometimes a single individual as employee in the country, and how to manage the compliance cost that comes with the requirements above small controller. So those are some of the practical challenges we see. And again, from my side, an appeal, if the Data Protection Commission can look at this classification to personal data points and not turnover. I know turnover is easy to identify, but if going forward, the commission can look at mapping or classifying controllers according to the sensitivity of data or the size of personal data they
That
handle.
subject.
That would be a way to look at it, and that will be more directly connected to data protection or the data that you handle.
Good. So Felix, obviously that is you in the mix here. So let me just come to you directly. Two key points were mentioned. I've registered a company. My intentions are to bid for a contract and win a contract. I've been registered for about 3, 4, 5 years. I've not done that yet. In my 6th year, I won a contract. So I'm now going to start operations. I now have to engage employees. Obviously, at that stage, whether employees or not, I've started operating, and therefore I'm going to qualify as a data controller. And this particularly may be the case for non-resident foreign companies where head office does everything until they have a project, they don't come in to do anything in Ghana. How do you treat such situation? Do you have an internal mechanism that can be used to identify these genuine concerns and probably not have them pay IRS, which may appear not really about the amount they are paying, but appear like they'll be non-compliant or this one about data subjects, data compliance issues in Ghana? Are there any internal mechanism that you can share with us?
Thank you, Augustine. There are internal mechanism for this. The motto for the Data Protection Commission is trust, transparency, and transformation. And data protection is all about documentary evidence. So we have received such issues on our desk countless time, and I'm sure my good people in the office will also say that even today we have received such requests. So there are internal controls for this. If your organization was not in operation, bring your documentary evidence. Once you bring your documentary evidence, the Data Protection Commission will make a determination on it and waive you. There have been a lot of instances the commission have waived a lot of
Hello, Felix.
organizations.
Not to come in, but when you say documentary evidence, what do you mean here? What should they be bringing to you to prove this?
So that you have a strong opinion that your business was not in operation. If your business was not in operation, what evidence are you bringing on board to evidence to the commission that your business was not in operation? If your business is not in operation, that means you are not paying tax. You need tax clearance certificate, and you have to write to us stating the reason why the commission must waive you. And these arrangements are in places, and some of the organizations are aware. And anytime you have issues like this, oh, my business was incorporated way back 2019, we are not in operation. The question is, bring your tax clearance. If you are in operation, if you were in operation, you'll probably be paying tax. And if you are not, you go to GRA. GRA will give you tax clearance certificate to bring to the Data Protection Commission. We look at it. We also request that you tell us the reason why the commission should waive you, because data protection is all about documentary evidence. What should we make a determination on that your business was not in operation? There are instances we also we visit the premises of this organization to spot check them whether truly they were not in operation. And the Register of Companies, the Company Act, also unlike before you even start business, they issue a certificate of commencement. I don't know whether they do it now.
No, they don't.
Aha. So
They don't.
so now the internal control is, if you are not in the operation, bring your documentary evidence. One of the key things we look out for is your
Mm.
tax clearance
The
certificate.
task grants and documentary evidence. And then to the
Yeah.
next point, he mentioned 2 points. So to the next point, about the appointment of a protection supervisor. That point is very key. So his wisdom from wisdom in assisting companies or client to comply. You notice that you have the threshold of revenue aligned with whether or not the person qualifies as a data control, a major, small, or large data controller. So these are the issues here. Now the question is, the key requirement that data protection would have been probably data sensitivity, or we look at number of data subjects. In this case, revenue comes into distort the issue. So I may have only one data subject, but I'm making about 5 million or more. And somebody has 100 data subject and probably making 50,000. With only one employee, I'm being asked to appoint a data protection supervisor, whereas the one with a lot of employees or probably even processing sensitive data is not being asked. Is this something the commission would like to look at, or do you already have things in place you can use to vary this to say objectively, yes, you may be major, you still pay the fees for a medium or large, but looking at what the number of data subjects you have, maybe you should just not appoint a data protection supervisor. Is that something you consider?
Yes. I think this question has been discussed over and over again. There are instances organization will be like, no, I am a small data controller. So the Data Protection Commission, we have a team that investigates some of these things. But at the long run, once you have a conversation with these people, you realize that they process a lot of personal information. The
Definitely.
key thing is you have to understand your main point of collection. Your website is also processing personal information. Your cookies is a very sensitive information. It is a text file that is embedded on your PC. The thing is, if you truly understand your main point of collection, you know that you process more than 50 people. There are instances where we engage one IT organization. they perform training for other organizations, and we asked them. They said they are small, and we've been monitoring their compliance over time. So every 2 years we are required to. They've paid the 120, like let's say on 2 occasions, and we've been monitoring. So when they renewed, the team, we wrote to them to have a conversation with them. We were interrogating them, and we realized that they even process more than 50 personal information annually. Can you imagine? So we started asking them question. Do you organize seminar? There are organizations also who will organize seminar or webinar like this, but they will not take it into consideration that we have processed individuals' personal information when we schedule a webinar to give some sort of education to people. It is all about understanding your main point of collection. Where are your main points of collection? The question is, have you put together a comprehensive record of processing activity to evidence that this is the exact number of personal information you process? The moment we probe them to do that, you realize that no, they process more than that. There are legitimate ones that are classified as small data controllers, and we take in consideration to help them, that once we realize that, oh, you are legitimate. Because let's look at someone at a Bosokan, a shop. How many times do they even issue a receipt? Some of them, the practice is there, but though they have ignored
They may
them.
not.
They are not collecting.
Yeah.
Okay, or let's take a mini shop, for example. So there are instances, just like we were saying, the understanding. One problem that I have is the data protection supervisors. Are they on top of their lake? Or they just go for the course and they go back to sleep because it is 2 years. When the 2 years period is due, then they chase the Data Protection Commission.
Yeah.
They chase it. So I think the main issue is about entities understanding their record of processing activities. The moment you do not understand this, you subject these processes to the Data Protection Commission with a lot of banter. And the banter is, most organizations always want to swerve compliance because compliance is expensive. And data protection is very expensive. Now that you have to train a data protection supervisor, you have to seek legal advice, you have to seek a cybersecurity expert, and all these things, once you sum them up and you are giving them data protection compliance advice, then you realize that the individual will be like, no. Then I think I am not a medium or small data controller. So the
Well
main
understood,
issue,
Felix.
the
Yeah.
main issue
So let
of
me go to Nina and come back to you on this same point. Just let me bring in Nina on this point. So Nina, let's look at it from where you sit. Felix has demonstrated now. I've tried to address the issues. Now the key question: some companies approach this whole process as box ticking exercise, and that is where Felix's concern is coming with. I do not qualify as such. I'm not this. I'm not that. From where you said, how do you look at it? Do you think data protection is a mere box ticking exercise, or this go beyond this and should rather be looked at more as a framework of trying to protect data in substance than rather just saying I'm compliant?
Okay, thank you, Augustine. So I believe, first of all, that the Ghana Data Protection Act was never designed to be a checkbox. That is my first belief, and I think that is what everyone should establish. Because if you look at the principles under Act 843, if you analyze them very closely, you see that those principles, they are like inherited risk-based principle, not to just take the box. But however, I can say that yes, there have been some improvement, but even based on the poll that we saw this morning, most of organizations are still approaching it as like compliant. I want to comply. But for us to move from just tick the box to more risk-based approach, we need, first of all, to start with our data inventory. In cybersecurity, there is a say that say you can never protect something that you don't know it exists. And a lot of these organizations, if you ask them, what are the data we should move from, like, are you registered? Because a lot of companies, they want to be registered to avoid penalty. But we should move from that angle and ask ourselves, what are the data that we are handling? And why do we have that data? Do you even have the inventory of all the data that you are collecting? Those data, do you know where they are coming from? Do you know the data subject of that information that you are collecting? And how long are you going to keep that information? And who is the person that is going to use that information? Is your information going to be processed by only the organization that is collecting, or there's going to be another third party? And that information even going to be be processed outside of Ghana? So once we don't have that inventory, it's going to be very difficult to avoid the approach that we just tick the box. So once now you have that inventory of the data, you ask yourself, this data that I'm handling it, is that all, or there are some that are missing? Because if I may throw this question to most of organizations, they cannot answer this question. Some, they can answer it partially. They don't know even the application. Do you know even the application that are processing your data? Those applications, where are they store the data? Is it on-prem? Is it on cloud? Those applications, did they have the right control? Once you cannot answer this question, it means that you are even sitting on the risk that you don't know in terms of the data privacy. So first of all, you have to do the data mapping. So the data mapping, it will be like your operational foundation that will help you not to drive this exercise by not knowing what you are doing. Another second point you have to approach, I believe even the director said that during his opening remark, we have to build accountability culture, a culture that is more accountable, not just awareness. Because let's pick any organization. You see that from the receptionist will collect the data. And that data, even the people at the car park, sometimes you have to register your name, your telephone number. Someone is collecting that data. And also the finance team too, they are processing personal data doing their payroll. You have also the marketing that are now doing the digital marketing to try to attract Ghanaian citizens. All these people, they are collecting data and they are using data, but you see that they don't even know that there are certain control that they have to comply as and when they are collecting the data, as and when they are processing the data. So once we are seeing the data protection as like is something that we need to comply, because remember that the Data Protection Commission, they have enforcement power, but we should move more like we are doing it because we are afraid that if we don't comply, we are going to pay penalty. We should approach it rather from the angle that it is our responsibility. It should be our greatest motivation that the data that we are collecting from the data subject is our responsibility, our dignity to serve the people. Once you have that mindset, that it is a privilege and honor that you have to save and protect the personal information of the data that the person that you are collecting, you'll be able now to take conscious on every step that you take. Another area that we have to look at it is from moving from policy documentation. If you look at most of the organization, go to their website, even someone can just pick any top organization. You see that we have this nice policy, privacy policy on our website, that when we collect the data of our client, we are not supposed to processing it without maybe your consent. And when we have some maybe a processing that rely on automated decision, we have to give you a consent. But let me ask you, most of organization now, we are using AI. We have agent AI. Has anyone contacted you that I'm using your data in processing certain activity? I don't think most of people have gotten that consent, but we are subject to say, no, before you can process my data, you have the right for human intervention. Yes, you have the model that is using my data. I want even to review the outcome of your model. And we know this AI, they are as good as much of the data that they have been trained on. And they have been trained on our data.
Yeah.
The policy said that you have the right, but you see, those policies, they are there, but go on the ground. Does the system, or do you have the measures that are ensuring that these requirements have been implemented? Maybe a system that will tell you, okay, I'm going to process your data using maybe an AI. You get an alert. Are you up to? You choose yes or no. Because also there's a policy that said they have to be the record of everything that you have that your data to be used to, but it's not there. And also even check some of the organization when you go and do their privacy gap assessment. They say that they have to be policies that if there is any incident, they will come and inform you. And you see that even internally, there is no really a structured strategy how they are going to contact you, how they are going to seek your consent. So I think it's more like compliance. We want to be compliant, but if we want to be honest to ourselves and do proper assessment, you see that we are having to move fully on risk-based approach.
So we are still on. So my understanding that we are still on compliance and not really on full risk.
Yes.
And I think you have really highlighted very important points. You talk about. So I understood the ecosystem. You are looking at the general ecosystem, bringing in AI, bringing in third-party vendors. You maybe engage third parties to bring in. Now to bring in wisdom. Having looked at Nina has really touched on a lot of issues here, and I noticed you were taking note. Now, maybe you get I was coming to you from here. Now, have you seen out of this non-compliance? Say they take your data, they've used it to train an AI, yet you've not been consulted. So the question is, have you seen how that led to any surge in litigations, damages, civil suits, employees taking on employers? You are in the industry and you do engage a lot with clients. What have you seen? What is happening in the industry? Should we be concerned? Are we not waking up?
Yeah, definitely, Augustine, we should be concerned. I think that the key risks that Nina has highlighted obviously should give any chief risk officer, any board member, CEO concern. If you're a data supervisor as well, you should be concerned. We don't have published figures from the DPC. Maybe Felix will be better placed to let us know to track from a data point of view. But obviously, once this awareness is going up, I expect that there would be more inquiries around data protection and what systems are in place. I've obviously seen more organizations asking from a service provider point of view whether you are registered with the Data Protection Commission. And that goes to the point that Felix made in his presentation. that beyond compliance, data protection also gives you a strategic edge, even to the extent that in bids, proposals you are putting in, if they concern handling data, organizations are asking for you to show that you have the right systems in place and you are registered with the Data Protection Commission. So that is definitely an increase that I am seeing. There's also been a court case in September 2024. An individual took one of the ride-hailing companies to court, and this was settled in the circuit court, the Adenta Circuit Court, where the plaintiff alleged that he has been a victim of identity theft, and an individual impersonating him as a driver for that ride-hailing company. And indeed, when the court went into it, the court found that the company, the ride-hailing company, as a data processor, failed to conduct proper identity verification checks. And this led to emotional distress and reputational damage for the plaintiff, and actually ordered the company to pay 1.9 million Ghana cedis in compensatory damages. So that's a clear example of the possibility for the law to bite, and this is getting judicial support in even compensatory damages for the plaintiff, to clearly show that data protection, of course, I think one thing we can leave with on this webinar is that it's not a compliance check the box activity. It's a strategic risk-based activity that should be embedded in the organization. And two, there are legal consequences for if you go against the act. There are legal consequences. In fact, the Data Protection Act provides for both civil and criminal liabilities for non-compliance with its provisions. And these offenses can go from failure to register with the Data Protection Commission, unlawful disclosure of personal data, and failure to implement appropriate data security measures. These are all offenses under the Act. And if you are found on the wrong side of the law, then the nature and severity of these offenses could range from penalties that could be in the form of fines administered by the Data Protection Commission, imprisonment, or even both. So the Data Protection Commission is empowered by the law to put in place administrative sanctions, and also the judicial system will support sanctions such as penalties, imprisonment, or both if you offend the law. So this is really critical and shows that the law can bite. And the Data Protection Commission has made it clear that 2026 is a year of enforcement. And I like that they are also increasing awareness. As they increase awareness and also take feedback around how to really manage a good balance between compliance costs and also the strategic importance of safeguarding personal data. I believe we should get there with the increased awareness and this being built into our culture.
Okay, thank you very much, Victor. So I think I still have a lot of questions, but to be fair, I need to also go to our participants. I'll pick some questions from the chat box and also ask for those who have raised your hands. I've seen you. I'll be coming to you soon. So Felix, so for this session, so that we're able to get a lot of participants ask their questions. Let's, if you could keep it very brief, those that require explanation, we'll provide. Those that could strictly be answered straightforward, we just go ahead with it. Now, from Cornelius, Cornelius says that he's a lecturer and he collects data for his research purposes. Is he required to register with the commission?
So that's the question is individual. The question is, if you want to register as an individual, the question is, are you a registered entity under the Companies Act?
Okay.
If you are not a registered entity, and you want to conduct individual research, you have to write to the Data Protection Commission for clearance. Then the commission will guide you on how to process personal data lawfully.
Okay, so just trying to that, and then he's also asking, or does his university have to register since he's doing it under the university?
Yeah, so if the university have registered, then the lecturer must see the data protection supervisor for the supervisor to give him general guidelines on how to work around some of these things on his or her project, because the key thing is personal data, and
Personal
personal
data.
data must be processed lawfully. So
Okay.
I will advise the lecturer to seek advice from the data protection
Data
supervisor that has
supervisor
been
of the
appointed. Yeah.
university. Thank you. So that's it for Canelo. So to Nina, wonderful Tigo want to understand how does he ensure that his employers protect his data and that is not used for the unintended purpose?
Okay, come again. I did not
So
get.
wonderful Tigo want to ask, how does he ensure that his employer protects his data, or his data is protected with the employer, and that they don't use it for unintended purpose?
Okay, so the first thing you can ensure that you can check, first of all, what is your employer. I'm sure if you are internal, you know that the kind of measures that your organization has put in place. But also, you have the right to ask that I want to know what information, the information about me, what the organization is using it about. So that is the first starting point that you can do. Put your request that I want to know. My organization have the data about Nina. So what are you using my information, all my information about Nina? Is it just maybe do my payroll, or beyond that? So once they respond to you, you now see that if there is any activity that your data is being used that we're not informed, and if you are not comfortable, you have the right to correct, or you have the right to withdraw. You can say that I don't want my data to be used for this activity.
Thank you, Dina. Back to Felix. So David wants to understand, so after registering and training a data supervisor, what next? What are they supposed to do? What is their role? What do they
My
have to
lord,
do? High level, yes, we know the high level, but high level, what are the key things they should look out for? What should the data supervisor be doing?
so the data protection supervisor must monitor compliance with the provisions of the law. And one of the tips I will give for the purpose of this webinar is, if you were a data protection supervisor, you must perform your record of processing activity, just like Nina elaborated on, your data inventory. Once you perform this activity, you will be able to know your lawful basis of processing personal data, because there are a lot of organizations that even don't understand their legal basis for processing XYZ data. So beyond registration, one of the key things you must consider is to perform your record of processing activity, perform your data mapping, perform your data inventory activities. And beyond that, it will translate to you implementing technical and organizational measures. Once you adopt data protection policies, you have to bear in mind that the output is procedures. So if you have the policy and the policy is just sitting down and you don't have the controls, which is the procedures and the processes, then you are at risk. Then you don't know what you are doing. So as a data protection supervisor, you must also talk with other practitioners who are experts in the industry so that they can also guide you. We are all aware that this is new, but there are good people like Nina Wisdom, myself, and others in the industry that you can contact for them to also give you general advice. Because most people have the strong view that when they register, that is all. Like you just said, tick box. Data protection has now become a tick box thing. It is not that. It is a practice. And once it is a practice, you must follow the data protection principles. How are you accountable to the data that you have? Because you should be able to demonstrate to me how long you are keeping data. We are talking about retention. Who you are sharing this data with, that is your third parties. Security measures you've put in place, you must be accountable to processing of personal information, and this takes time. Your policy should give you maximum output, and that output is your procedures and processes. Thank you.
Thank you. So, Wisdom, we have an anonymous one who wants to understand. He believes the state and government institutions gather a lot of data. You walk into every office, either you have to log into a logbook or you submit an application, they have a lot of your data in there. His concern is that what concrete enforcement step is the commission taking? So I'll come to the commission on that, but what, from your perspective, what do you think we should do? Because they would have taken also your data at one point or the other. Do you think the system is such that our data is safe with them, or there's something else that the commission should be looking at doing when it comes to the state institution? They are brothers, and sometimes they tend to be a little bit relaxed in that regard. So from your perspective, what will you suggest?
All right, all right. So I hope you are not pitching me against the organizations. Yeah, but one thing is clear. Felix Otabil mentioned that the Data Protection Act is not for just private organizations; it's for all. It's so, and that includes governmental organizations. And I believe that this awareness should also go to governmental organizations. And I believe we have a number of participants who are also coming out of our governmental organizations, statutory bodies, etc. And they are also taking this awareness serious. And the actions that should follow, really, if you're a data controller or a data processor and you have not registered with the Data Protection Commission, then you have to do that. Beyond that, what we have talked about, the policies would have to be put in place, controls would have to be put in place, not just to sit on tables, but they would have to be implemented. And if you have concerns, you reach out to a qualified expert to help you in that regard. We've always had this joke in Ghana that if you drop your CV in an organization, the next moment you could be getting the CV back from the plantain seller, and it's true. And in the past we only talked about it as potentially meaning that your CV will not be looked at, and we left it there. But what it is today is that is information that is going out. Your CV would obviously have your personal data, and potentially people can even use payroll reports and give that out to a plantain seller. But this awareness is so important. Down to specifics, the cybersecurity experts would add to it, but I am always very focused on one, the awareness. Once you have the awareness, and then the tone from the top, this should not be left to the operational team, but this should really be driven as a tone from the top. The chief director, the minister of a ministry, or the CEO of a governmental organization should be aware and should drive compliance with the Data Protection Act, and also drive implementation of policies and controls to ensure that we safeguard our data. So the good observation from our participants, and it's good that we have DPC, the Data Protection Commission, on the call to also direct some awareness to that area. But overall, it's important that as a country, there is an uptick in understanding privacy and how we maintain personal data and safeguard it, which is one of the core principles under the Data Protection Act to safeguard personal data. Thank you.
Data. Thank you. So now to our online participants, those that have their hands up. First, Gifty. Gifty, if you can unmute and ask your question. Gifty Dodgy, I hope I get the name right. Gifty, if you can unmute and ask your question. Hello, Gifty. Okay. So Gifty, yes. So Gifty, you can ask your question now. You can unmute and ask your question. Okay, so let's move to Nana Poku. Nana Poku, if you can unmute and then ask a question. When Gifty is ready, we'll come back to Gift. Okay, so I see Gifty is back now. So Gifty, please proceed. So proceed. Nana Poku, please proceed.
I don't know if I can be heard.
Yes.
Okay. Good morning, and thanks for the opportunity.
Good
So
morning.
I think my questions is in twofold. The first one, I don't know whether we still have representative of the commission on call, is to the effect that usually at times you visit an office or an entity and you are given a visitor's logbook. Now, this visitor's logbook contains the names of other persons that came in before me, and I'm going to add my data. What it means is that the next other person who comes into this entity is going to see my name, my details, where I work, who I came to see, and all of this. I don't know what the commission is doing about it because I see it as a breach to my personal data because I have not come there to share my data. I have only come there to maybe make business inquiry or to make a visit. That would be the first part of my question.
Okay.
The second question would be, to me, I would like us to now move into the intersection of data protection and that of human rights protection, because I realize most of the discussion is skewed towards the protection of organizational data. Now, to be more specific, assuming I am an employee of an organization, to the best of my knowledge, when the day I decide to terminate this employment relationship, whatever data they have on me, I should have the right to collect it. So, to be specific, my question is the right to be forgotten. I came, we had an employment, you have my birth certificate, you have my school certificate, you have all of this data about me. Now I am leaving and I say, look, I don't want you to keep any data on me. What right, how does the commission move, or what does the law say about enhancing this right? Thank you very much, sir.
Thank you so much, Anapoko. Quickly, I'm not sure Felix is on. Felix, are you on? If not, I'll come to. So let me take this from Nina first. You've gone to just make inquiry in an organization, have a meeting. You didn't go there to share your data, but you've given a logbook. You've seen other people's details and do also others who you call it come and see your details. Are there any issues of concern that we should have? Nana Puku has concerns in this. Are his concerns justified?
Okay, thank you very
And
much.
what should be done?
I think I totally agree with Nana because we are supposed to protect our information, our personal information, not to be disclosed to the people that are not supposed to have it. And as he mentioned, you go, I have written my name, my telephone number, where I'm working. So these, they are already the privacy. So I think what organizations should do, and I have seen some that have started implementing that control, is to make it more digital. So you have a where you can do your record. Once you enter, no one will see because they are a system-based record. But we have to move away from this book that you see at the reception because it's a totally breach. But you see, because people are not aware of their right, it's few people that they will see that this is against the data privacy.
Thank you. Nina. So wisdom under a minute. You your employment has been terminated. You should be forgotten. You are no more earning anything from that employer, and so should they not keep anything about you. Is that a legitimate call?
Yes, I agree. I agree that it should be, and Nina did mention one of the rights you, as the data subject, you write to your employer. In fact, the data subject may request the data controller to correct or delete personal data about the data subjects that is held, and that is provided under Section 33 of the Data Protection Act. And that's if it's inaccurate, if it's irrelevant to the data controller, if it's excessive, if it's out of date, if it's incomplete, misleading, or not obtained in the right way, then the data subject can make that request to the data controller. So I believe it's within your rights. Note that the data controller would also have a retention policy that should be in line with the law. But the data subject also has the right to make a case if, for instance, they believe that it's out of it's not needed for the data controller to hold that data at that point. That should also be balanced with, as an organization, the organization would have audits, for instance, from a tax point of view. The organization will have to undergo audits. And the tax law requires the organization to hold data for a minimum of 6 years. So your payroll data cannot be deleted the next day you leave the organization, because they would need to hold it and be able to present it during a tax audit. Okay, so that balance, we should be clear of that balance. If it's data that they would not require in any case beyond your stay with the organization, you can make that case and write to the organization. But there are other obligations that the organization would have to satisfy. And a typical example is the tax audits that organizations go through, and they have to retain documents for a minimum of 6 years.
Of
And
6
that should be
years.
put into perspective. You have the right to write, make the request, and then the organization to assess accordingly.
Thank you,
That should
Wisdom.
be within the law.
Okay, thank you, Wisdom. So, Gifty, one question from Gifty, if you can unmute and ask briefly, so we are able to go to the others also, take other questions. Gifty. Okay, on to Bismarck. Bismarck Connie. Yes.
Okay,
Bismarck
thank you
Connie.
very much. Good afternoon.
Good afternoon.
Okay. Um, I'm very happy to be on this webinar because I have understood a lot of things. My organization has not registered before with the Data Protection Commission, but we had a call, I think last 2 years or so, we had a call that we're owing and we had to pay. So we went to the office, and then I think we made a payment. We made some payment. That we have to pay. So we wanted to engage them to understand what was actually happening, because we've not been privy to this data protection matters regulations. But our effort to reach them in the office proved futile. Up till now, we've not been able to meet with anybody. Nobody has called us again. So I'm happy this thing is coming up, and the understanding is that we have to register. And so once we were not registered, I don't know why we were called to make payments. So if I can get some explanation to that. Then my second question is, what will be the audit modalities on with regards to data protection in case we are registered and auditors come to audit us? What are the things that they will require? And then I think I wanted to ask a question: the number of years that data should be kept before being discarded. And I think Wisdom mentioned that is 6 years. I don't know if that is correct. Thank you.
So this how, so the first question, I believe, you've seen Felix. You can walk to the data protection office now and reach out to him. Alternatively, you can reach out to Deloitte for assistance. The second one, Felix, I don't know if you want to take on or maybe when they come, you'll be able to deal with the two issues. But he was talking about payment and not getting the response. I don't know if you like to briefly, 15 seconds, touch on that.
Okay, I think the Data Protection Commission, our helplines are very active, and once WhatsApp, all the social media outlets, once you call us, we will answer to the call. But the question is, how did you arrive to the commission calling you to inform you that there is an outstanding balance you are required to pay? I am pretty sure someone in your organization made an effort to register, because
Yeah.
if no one has made any effort to register, we will not even have your information in our database to call you to inform you that there is an outstanding balance on your account. So, with
Okay.
all due respect, I would advise that you come to our office or go to our website. All the helplines, the contact are there. Reach out to us and we will assist you resolve this.
Thank you so much, Felix. We've gone beyond our time now. So unfortunately, for those who have their hands up, I would kindly indulge you to type in your questions in the comment section. We will endeavor to reach out to all of you with responses to your questions. Those questions in the comment, in the chat box that we cannot respond to, be rest assured we will try to get in touch to respond, to provide appropriate responses to those questions. It's been very interactive. It's been very insightful. And thanks to all my panelists for your patience and for walking us through this very important webinar. And we are most grateful. I can see already you are receiving applause, and your responses have generated very positive feedback. I thank all of you. Wisdom, thank you. Nina, thank you. And to time, we'll put up our feedback link. Our feedback will be put in the chat box now for you to just give us a quick feedback on how this session has gone so far. Just click on it. You see a number of questions. They are not they're just for you to tick and then give us feedback on how the session has gone. If you want another session or you have a proposed topic that you would like us to take up for our next webinar. On that note, I will bring in Wisdom Plano once again to give us our closing remark. And as a host also of the program, if you have anything else to add, you can go ahead. Thank you. I've been your host, Augustine Donko.
All right, Augustine,
Yeah.
thank you very much. Definitely a pleasure to host this important conversation. And I've seen from the chats, it's been very engaging. Mr. Quentin Akrobeto from the Data Protection Commission, Director, Regulatory and Compliance. Thank you again for being our guest speaker. And I would also want to thank Felix Otabil, who leads the compliance team, DPC. Thank you very much. Great presentation you did, and for availing yourself for this panel discussion. Nina Colley is an associate director with the Deloitte team here. She is a cybersecurity expert, and so you can see that the angle that she takes it from very practical. Nina, thank you very much for joining us and sharing your insight. To our participants, I want to thank you all for joining. I believe that your expectations have been met. We've had a very good conversation around what our compliance requirements are, and that's really has helped us to understand what you need to do as an organization handling personal data. So if you're a data controller or a data processor, you know you have to register with the Data Protection Commission. Leaving this call, you should also know that it's not just about registering with the Data Protection Commission and showing a certificate, but it's about putting in place the necessary safeguards, which is a core principle of the Data Protection Act, putting in place the necessary safeguards that will ensure that you safeguard personal data so that they do not get into the wrong hands, you do not grant access to unauthorized persons, or you do not offend the Data Protection Act in any way. I would say that this is a call for the C-suites of businesses in Ghana. Among the issues that you discuss, data protection should be central to those issues. How do you put in place the policies and the framework to ensure that as an organization you comply with the act and also safeguard personal data from getting into the wrong hands? And that helps you to avoid the risks that it comes with, but also gives you a strategic leverage in the space. You engender the necessary trust among stakeholders that you deal with, and can also safeguard the data of the data subjects that you keep. This has come from the Deloitte regulatory team, and it's been a pleasure hosting all of you. We wish you the best of the week ahead. We'll be sharing notes through email to you. If you'd want to reach us or the Data Protection Commission for any inquiries, we are happy to address any questions you may have around data protection, your regulatory compliance, and legal entity management. Have a good afternoon. Thank you very much.
I'm just a little bit concerned.
Don't worry, we'll get there.
Have you heard the news?
This morning, a groundbreaking initiative